Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And this is my private Facebook group. And so if you're in foreclosure or about to go into foreclosure and you want some help from like-minded people, you can join my Facebook group. Okay guys, today we're going to talk about some important things. Basically, I wrote this presentation for y'all. Foreclosure mistakes you don't want to make and how to fix them. A lot of pro-sayers make common mistakes that I see, and I just made this presentation to show you guys some things that you might make, or you might know someone that's made these, how to fix them if you do make them. Okay, so the first thing and the most common mistake people make, if they are the plaintiff and they want to sue their lender, improper service of court papers. The mistake is not serving the other side correctly or failing to provide or to file a proof of service. This can cause delays or even dismissal. Your initial complaint, if you are the plaintiff, you must personally serve via personal process service company like ABC Legal, not by certified mail. The fix is to learn your jurisdiction service rules. Okay, process service. Once served, you download the proof of service from ABC's website and file that with the court. That is when the clock starts ticking. For subsequent court filings, you must also write and sign and file a certificate of service with the court. Every time that you file something, you have to serve the other side a copy of that, and always keep copies. The next thing we're going to go over, another common mistake, is listening to the wrong people. The mistake is falling for sovereign citizen or mortgage elimination scams. Here's an example. Send a magic affidavit to expunge the debt or just declare yourself exempt. Judges see through these. The fix is to stick with real law and real procedure, case law, statutes, and rules of civil procedure. Avoid YouTube gurus or trust packages that claim to wipe out your mortgage debt. Those don't work, guys. They just take your money and they don't really help you. The next common mistake some people make is putting property into a fake trust. Mistake: transferring the house into a common law trust or a land patent to avoid foreclosure. Courts treat this as a sham and may even cloud the title. Fix: if you want to use a trust, use a properly drafted, legally recognized trust with a real trustee, and understand that it won't erase your debt. If the goal is estate planning, fine, but don't expect it to stop foreclosure. In fact, it just makes things more complicated, and judges see through these as well, guys. So putting your house in a trust doesn't work. Don't do it. It doesn't make sense to do it. Missing deadlines. Okay, this is bad, guys. Some people miss their deadlines and you can't get back a missed deadline. Not filing an answer or a motion on time, or missing appealing deadlines. Foreclosure cases will move fast, so keep a calendar with all your deadlines. File even a short answer to preserve your rights. If you miss a deadline, immediately file a motion for leave or a motion to vacate. Default: explaining good cause. Now, filing the wrong pleading. This sometimes happens to people. Filing motions that don't exist, like filing a motion to abate foreclosure in a court that doesn't recognize it, or filing in the wrong court. Fix: always check your state rules of civil procedure or federal rules to make sure that the motion or pleading is recognized. Model your filings on real case dockets from your jurisdiction. Guys, there's lots of us in my foreclosure group that we can help you if you have questions. If you realize you filed the wrong document, file a notice of withdrawal if the court allows, to take it off the record, or file a motion for leave to amend or to correct or replace it with the proper pleading. If unsure, file a simple answer first to preserve defenses. You can always amend later, but always be cautious about this and make sure you do file the right thing, guys. Ignoring the chain of title is a big mistake people make. Not checking the county land records. Many pro se litigants argue fraud without evidence. The fix to this is to pull your deed of trust and all assignments from the county recorder. Compare them to the SEC trust records and PSA dates. Look for breaks, out of order filings, or missing endorsements. Attach these as exhibits. Forgetting federal claims. Another mistake, only raising state law claims like wrongful foreclosure and ignoring federal statutes like FDCPA, RESPA, and TILA. Fix. Even if the court dismisses federal claims, they give you leverage. Include them in your complaint and counterclaims. It opens the door for statutory damage and attorney's fees. Another common mistake is focusing on magic words instead of evidence. Mistake. Thinking that writing fraud or void in all caps will win. Courts need facts, not buzzwords. Fix. Support every allegation with facts and documents, dates of assignments, copies of notices, docket numbers from prior cases, etc. In other words, you got to use real evidence, guys. Not preparing for appeals. Mistake. Thinking you can fix everything on an appeal. Appeals only review what happens in the lower court. So to fix this, start with the trial court level and build a good record. Object when necessary, file exhibits properly, and keep transcripts. That way, if you have to do an appeal later, it's all there, and you're not bringing in new information. Giving up too soon is a big mistake. Walking away after one bad ruling. Many pro sayers think that's the end, but it isn't. Usually you have motions, appeals, or even bankruptcy options. One loss doesn't mean the fight is over, guys. Number 11, not properly formatting your complaint. It'll get dismissed under Rule 12b-6. So, filing a complaint that is vague, confusing, or lacks specific factual allegations. Many pro se litigants just tell their story without separating causes of action, or they cite law without tying it into facts. This makes it easy for the bank's lawyer to move for dismissal under Rule 12b-6, which is failure to state a claim. To fix this, follow the structure courts expect. You need a jurisdictional statement, the parties, who's suing who, statement of facts, and short numbered paragraphs of what happened in order, cause of action, separate counts, count 1, FDCPA, count 2, wrongful foreclosure, etc., prayer for relief. So your complaint must be properly formatted. Tie each cause of action to specific facts. On July 2nd, 2024, defendant foreclosed without providing notice under Texas Property Code, blah, blah, blah. So you see these have to be like this. Keep legal citations short, focus on facts that match the legal standard. If the court grants a 12b-6, immediately ask for leave to amend. Don't give up. Courts often allow at least one amendment, especially for pro se litigants. Ignoring court formatting rules. This is another big mistake. If you submit a filing that's in the wrong font or font size, not double-spaced, not paginated, numbered, printing on both sides of the paper, stapling instead of paper clipping, missing signature or improper notarization. Okay, this is a fix, okay? Make sure that you check your court's local rules, okay? In most cases, the font size is Times New Roman or Arial, 12 or 14. 14 meaning the headings are larger than the rest of it. Spacing should be double spaced. And only use single spacing for block quotes. Margins at least 1 inch. Pagination, you got to number every page. Paper should be one side only. Exhibits attached as labeled tabs, paper clip, or binder clips, but never stapled. Signature should always be signed, if electronic, with the S by their name, or handwritten if not, filing electronically. If notarization is required, make sure that that's notarized as well. If the clerk rejects your filing, correct it and then refile it. Citing case law in the complaint is a big mistake, guys. Don't do it. Packing the complaint with case law citations. Many pro se litigants try to prove their case in the complaint itself by quoting court opinions, statutes, or long legal arguments, but a complaint is not the place for that. It's for facts. Judges get frustrated with legal treatise-style complaints. Fix. Keep complaint focused on facts and cause of action. Reserve case law citations and legal arguments for motions and briefs. Believe me, you'll have your chance to cite your legal stuff when we get to that. So if they file a motion to dismiss, you'll have to write an opposition to motion to dismiss, and then you'll have your case law and your memorandum of law or appellate briefs. In the complaint, it's fine to reference the statute or rule violated, like the FDCPA 1692D or Texas Property Code 51002, but don't attach case law. If you accidentally load a complaint with citations, you can fix it by filing an amended complaint that strips it down to the facts. Filing an answer without counterclaims if you're in a judicial foreclosure state. This is a big mistake people make. They just file an answer without doing counterclaims. In judicial foreclosure states, many pro se litigants only file a bare answer that just denies allegations. By doing this, they miss the chance to assert counterclaims such as wrongful foreclosure, FDCPA, res patilla, quiet title. Once waived, many counterclaims cannot be brought later in the same case. To fix this, when you file an answer, also include new manner and counterclaims in the state courts or counterclaims in federal courts. Counterclaims turn you from being purely defensive into being an offensive party. Now the bank has to answer to your claims. Common counterclaims: lack of standing, defective assignments, breach of contract or notice violations, FDCPA or RESPA violations, wrongful foreclosure, quiet title, and the list goes on. If you've already filed an answer without your counterclaims, you can still fix it early in the case by filing a motion for leave to amend your answer to add your counterclaims. Courts often grant leave, especially for pro se litigants. An answer without counterclaims is like bringing a shield without a sword, guys. Think about that one. Not knowing the proper time to conduct discovery is another one. Mistake. Many pro se litigants either skip discovery entirely, or two, they try to send out discovery requests, which are interrogatories, requests for production and admissions, before the court even allows it. If discovery is premature or improper, the other side objects and the judge may disregard it. On the flip side, if you miss the discovery deadline, you lose the chance to demand critical evidence, like the note, assignments, or servicing records. To fix this, check your court rules. In federal court, discovery generally begins after the Rule 26F conference, after the judge issues a scheduling order. In state court, discovery timing varies. Some states allow it right after the answer is filed, others after a scheduling conference. Track deadlines. Discovery usually has a cutoff date in the scheduling order. You miss it and you can't compel production later. Plan discovery early. Make a list of what you need to prove your defenses and counterclaims, assignments, accounting, communication, servicing notes, and tailor your request to those. If you miss discovery or send it too early, you can fix it by filing a motion for leave to conduct late discovery showing good cause, or filing narrow, focused request after the proper start date. File discovery too early, it gets ignored. File it too late, it gets denied. File it on time, it gets answered. Okay, guys, I hope that these little tidbits were helpful to some of y'all. I know that there are some websites that I can show you one here that some people have been going to. It's called Freedom from Government. And this is a typical website, freedomfromgovernment.org. And this is misinformation, disinformation that's going to get you in trouble, if anything. If you look into some of their workshops and classes that they have, they talk about, here we go, mortgage-free, fend foreclosure. Okay, so, I mean, this is all disinformation that's going to help you lose your house a lot faster, guys. So, just so you know, beware of these things, and, you know, if you are like some people, you might actually go to jail for doing some of this stuff. There's a sovereign citizen sentenced to prison for debt elimination scheme here. This is from 2015. It's kind of old, but people are still doing this, guys. Nothing's changed from 2015 to now. And these people, they had to go to jail for what they thought was, they got disinformation from someone else. They thought they could discharge their debt, and it just did not work. So again, you guys, don't fall for these things. I hope this information has been helpful. And if you guys have any questions or comments, you can leave them below or send me an email. My email address is foreclosurehelp777@gmail.com, and I hope everyone has a blessed day.